And welcome back to the Law News Network. I'm your host, Amy Dash, and I'm joined here by Marc Fernich, who is an attorney here in the city.
How are you, Amy?
Good, how are you? You're a criminal defense attorney.
Yes, but
now,
it's furnished.
And your sorry.
And we're also got
and
some volume
your
problems.
computer is going.
Sorry about that. We fixed it. It's furnished, by the way.
Yeah, it's got a mind of its own. Listen, Marc.
Yeah.
We have this deputy sheriff who's on trial. There is a lot of evidence that other people from the sheriff's department tried to cover up this crime, tried to help him. Yeah. Those text messages, are those in and of themselves enough to incriminate him and implicate him in the abuse of this elderly woman?
Provided that they can be properly authenticated, which means they have to be proved admissible in court either with or without a witness to verify what they are. They're highly incriminating as statements in furtherance of a conspiracy or an effort to obstruct justice. They're bad. They show evidence of a guilty mind.
So can you take that evidence of a potential conspiracy and get a conviction on an attempted murder charge based just off of that? Because there are questions over how she had incurred the injuries. So that's in question. That's not so cut and dry. But can you take those text messages of him conspiring with his fellow deputies to get that murder conviction on attempted murder?
You know, it would depend on Florida law where this trial is taking place. Under federal law, which is primarily where I practice, the standard of legal sufficiency is very low, and there's no real hard and fast rule about what it is. In federal court, even the testimony of one accomplice witness without any sort of corroboration at all is enough as a matter of law to convict somebody. It seems to me that without anybody to directly testify against Bybee, it would be a reach just on the basis of these text messages alone, because they could be subject to varying interpretations, and it's more evidence of a cover-up than the actual deed itself. On the other hand, we don't have the victim.
Yeah, the victim. Yeah, the victim took the stand.
Oh,
actually.
She did take the stand.
Yeah, because you were in court when she took the stand. That's why you missed that part.
Yeah, I actually have the
practice.
Regular gig in your
Right.
courts, so I can't do this full time. And so what did she say?
So how compelling
precisely?
is that? Because what they're trying to do is paint her as somebody who's not mentally well. She's denying that. She's saying, I'm totally with it, and this is what the guy tried to do to me. He tried to force medication down my throat. He tried to poison me with carbon monoxide. The fact that she's 79 and that several people from the police department are trying to paint her as somebody who doesn't know what she's talking about. Do you think that it was helpful to the prosecution to have her take the stand?
Absolutely.
Or not in the face of those accusations?
It's a no-lose proposition, because
Why?
even if she's incoherent, that shows somebody who's vulnerable and easily taken advantage of.
Right.
And on the other hand, if she was coherent, credible, and compelling, she's still an elderly and woman who's in a vulnerable position relative to this powerful police officer. So if she testifies cogently, it's great for the government, and if she testifies in an enfeebled way, it just makes her look more sympathetic and him look more like somebody who would take advantage of a vulnerable victim, I should say, of whom there are no shortage in Florida.
Right, and also you have to question the nature of their relationship. Why does this deputy sheriff have this ongoing relationship with a 79-year-old, and then he's brought up on charges related to using her identity for different instances? So that it all kind of ties together, but is that enough to prove attempted murder?
Well, based upon her testimony, which you just aptly summarized, it's certainly enough to prove it if the jury believes what she says, and then there is this at least circumstantial corroboration in the form of these emails. So it sounds like a pretty good case from the government standpoint, and it's obviously, we hear about the blue wall of silence all the time. It would be more surprising if they came out against Bybee, the fellow officers, than the fact that they're apparently trying to support him.
So are you familiar with the exploitation of the elderly statute, or the general ones, and what are the elements under that you need to prove in order to get a conviction?
I'm not familiar with it, other than having read about it briefly in the context of this case, because we don't have a parallel statute criminally here in New York. Usually if it's a vulnerable victim, Amy, that's an aggravating factor in terms of sentencing, and sometimes it can bump up the severity of the crime by a degree or two, but it doesn't take a rocket scientist to figure out what the gist of this is. It would be a vulnerable victim and somebody in a position of trust relative to that victim abusing the position of trust. Now, of course, this officer, Bybee, has no inherent or natural position of trust, but evidently he developed a relationship with her over time, and I wonder, although I can probably deduce how much control of her finances he inveigled over a period of time. And unfortunately, this is not uncommon with the elderly people, and I'm sure it's a major, major concern for authorities in Florida where there is such a heavy concentration of elderly people.
Yeah. And so earlier today, they brought the neighbor on the stand. And we had Ron Blitzer in here who works for LawNewz, and they were showing pictures of the victim's injuries and asking this neighbor who has a background in trauma care to opine on how she got the injuries and whether they were fresh or not. And that really sounded to me like expert testimony. But
That's
Ron was saying it was an opportunity to get the pictures in. Even though the other side said, hey, you haven't been proffered as an expert.
Right.
Do you think that's the case?
That sounds pretty fishy to me. That sounds like a pretty fishy ruling. As you were describing it before you gave Ron's summary of it, and my brain started going, this is pretty weird to proffer expert testimony in the guise of a lay witness. So she really didn't witness anything that inflicted the injuries, correct? She didn't see...
She didn't, no. She just came upon the scene and used her background in certified trauma.
It seems to me that they could have gotten, and she was familiar and acquainted with the victim?
Yeah, next door neighbors.
And was she able to testify to Bybee visiting frequently and all that?
That didn't, no. That didn't.
She was not privy to the nature of their relationship at all, right?
Not that I heard from the testimony.
Because it sounds like a way to sneak in a supposed expert to also give factual testimony and using the mantle of her expertise to bolster the factual allegations. One would think in the state of Florida that somewhere in that great big state of Florida, they could find a certified trauma expert who didn't happen to live next door to the victim. So that's sort of a fishy cheap trick.
So do you think it was to just get those pictures of the injuries in there and to elicit sympathy from the jury?
Well, it serves a dual purpose, okay? Somebody has to opine on how the injuries were inflicted, and you would ordinarily get a normal expert to do that. It's not surprising that the pictures come in. They could be admitted for a limited, I don't want to get too out in the weeds for the viewers, it could be admitted for a limited purpose with an instruction to say you're only supposed to consider this for the basis of the expert's opinion, but they smuggled it in there as direct proof of the injuries for the shock value as well. Now, whether that's permissible or not is another question, but the judge allowed it to be done. It sounds, based on your recitation of it, quite dubious from a defense perspective.
Yeah, and then we saw another colleague get up on the stand, Deputy Michael Day, and what happened was he became a hostile witness, according to the judge. Just explain what that means,
shock,
please.
Right? Well, because he's supposed to be testifying on behalf of the take that right back. Sorry about that.
He's not testifying
you see
about
where
prostitution.
my head is at, for better or worse. For the prosecution, you see what I think of prosecutors, but we'll take that back. He's supposed to be testifying for the prosecution, but he's coming to the aid of his colleague and fellow officer, and he's not giving an inch for the prosecution. In fact, he's trying to defend the defendant. So the prosecution then says, hey, this guy's hostile to us. I want to examine him by cross-examination with leading questions, because he's not doing what we expected him to do. He's against us, and I want to be able to lead the witness.
And you can do that if you feel that somebody's holding information back, or is it just based upon someone making statements that are inconsistent with what they said previously?
No, it's more than an inconsistency. I mean, look, it's another, and again, part of this is me just pontificating without knowing the real nitty-gritty and minutiae of the case, but they had to have known when they subpoenaed this officer that he was going to be unfavorable and adverse to the prosecution. So this had to have been a deliberate ploy. They could have...
So what would be the strategic advantage to doing that?
To getting him up there and parading him to show the jury that this guy is not being forthright, he's lying, he's covering up, and then to get the double whammy of asking the judge in front of outside the presence of the jury, he's hostile. They'll go to the sidebar and say, he's hostile, can we start cross-examining him? Yes, 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 and then the jury will see the shift in tone with the leading questions, and presumably the witness then will become more forthcoming or risk possibly a contempt.
Right, and so what do you think about just so many people from the sheriff's office trying to paint this woman as mentally unstable, not just on the stand, but in messages and conversations that were revealed during the investigation and when they're talking with Frank Bybee, which is obviously a violation of the proper procedures of investigating a crime when your colleague's involved, to actually discuss it with him and get his take on it.
Look, time will tell, obviously. I believe in the presumption of innocence, not with respect to the officers who are apparently in league with Bybee in some way. I won't judge the propriety of their behavior until there's a verdict in the case. If there becomes if the jury finds Bybee guilty and finds that this woman was not so enfeebled and not a liar and not a manipulator, then I'll quickly come to the conclusion that the officer's behavior was quite reprehensible in trashing her. But once there's a guilty verdict where she's found to be, if there's a guilty verdict where she's found to be believable and they rejected these officers' testimony, then it will be quite apparent what they've done, which is the blue wall of silence. And we all know about this in our field.
Right.
This doesn't seem to be a great case to invoke the blue wall because, you know, what motive does a 79-year-old woman have to fabricate something like this? And she's obviously, whether she's infirm or whether she's crystal clear as a bell in her testimony, she's obviously a very sympathetic victim. So
then how
not a good look for the police in Sarasota, Florida.
Right.
And it's not the first time they've had bad looks, too. As we think back to the Zimmerman era, there was a whole lot of chaos down in that area of Florida at that time.
Yeah, sure.
Not a good look.
So then how would you have defended this deputy sheriff?
Well,
would you have taken this same approach of trying to paint the elderly victim as mentally incompetent?
It's so easy for one defense lawyer to Monday morning quarterback another defense lawyer, and I don't have the knowledge of the case to second guess that person. It's not the first choice strategy that you would use to beat up a 79-year-old woman.
Right. I mean, she's got the bruises.
Yeah. I mean,
yeah, the car running.
You could
garage.
Well, you know,
with the poison.
He may not have anything else to go with. That's the point. I mean, sometimes necessity is the mother of invention. If he has no other choice but to go after this woman, that's what he's doing. But if you're going to suggest that she has memory problems because of her age, I mean, it requires a delicate touch to do something like that.
Yeah.
You're going to have to do it adroitly. And I haven't seen the style of his cross-examination, how he's been doing it. I mean, this may be his only defense.
Yeah, I mean, they're saying that this woman may have fallen, and that's how she got the injury.
Well, you know, when you were talking about the bruises and the cause of death, that was where I was going with it in my head. You know, she's old. Maybe she fell in the house. Maybe she had injuries. But this requires great, great care as a defense lawyer. And ultimately, in a case like this, Amy, this is a case where you look for a plea. I mean, it seems like a very unseemly kind of case to take to trial, and from a defense perspective, it can't possibly have that much jury appeal.
Yeah, I would agree with that.
Unless you somehow pack the jury with unapologetic supporters of law enforcement, you know, give me liberty or give me death type support.
Yeah, and that's possible, and also maybe he's relying upon the jurors buying into what law enforcement is saying, because we see that the majority of the witnesses are his colleagues, and we know that law enforcement are trusted sources on the stand.
Sorry about that.
That's okay.
I'm going to try to shut it off.
That's all right.
That's probably more interesting than me, to be honest.
Yeah, we love it. Mark's computer has a life of its own, actually.
I think I got it now.
I don't know if we can play all of that noise without copyright infringement. So we better turn it off.
I think I'm trying.
But let me ask you something.
I'm thinking that the fact that they're all law enforcement witnesses and all telling the same story is not going to work in the defense's favor. It doesn't take a genius to figure out.
Seems to be backfiring.
Yeah, I think it would backfire. And these obviously aren't witnesses called by the defendant. We're on the prosecution's case right now.
Yeah.
So the fact that they've been declared hostile. You remember from law school the tort doctrine, res ipsa loquitur, the thing speaks for themselves.
Yeah.
If you've got 10 10 police officers all saying the same thing, and it's a pretty far-fetched story, and there is evidence that they're trying to cover up for their brother officer, jurors aren't stupid. You know, they're going to see that for what it is.
Yeah, so how important then is it to provide an alternative explanation as to what happened, like, oh, she fell, that's why this happened, versus the defense merely just trying to prove that there's enough reasonable doubt that he didn't do it?
For us as lawyers, reasonable doubt is a great concept, and holding the government to its burden of proof is something we do as lawyers. I think before a jury, they want to hear another narrative. So I think it's very important to have theme development in your case, and this is something that I teach my students at law school all the time. Whether you're advocating on appeal or at trial, you have to have your own story to tell the jurors. And just saying that she's old and she's got a bad memory isn't going to get the job done. More along the lines of she fell, she had an accident in her house, something else to give them to hang their hat on. And of course, despite the presumption of innocence, despite the fact that the defendant has no obligation to testify or prove anything, they're going to want to hear from the officer in the case.
Yeah, so you think it's more effective to sort of just put that thought in their mind to enhance the reasonable doubt argument?
If there's something there to back up the idea that she fell, if there are
But isn't that just based, Mark, on her being old? I mean, isn't that a stereotypical alternative? What is there to support that besides, oh, she's old, she's mentally unstable, and she fell?
No,
that's pretty generic, isn't it?
If they have evidence of her seeking medical treatment for these kinds of conditions, I mean, you can get that all by subpoena and by discovery. There has to be something to support it, just not wild speculation, or, as you said, it's, you know, your instinctive response to it is one of sort of not quite revulsion, but it's just dirty.
Yeah, exactly. So now let's listen a little bit to testimony from Sergeant Jonathan Allen, who is going to talk about what he thought about the victim's story when he arrived on the scene.
Have you completed?
Yes, ma'am.
Just for clarity of the record, it is 16A, correct, not 6A?
Yes,
I just want the record to be clear on it. It's 16A as opposed to 6.
All right, so after having read what's been marked and admitted as State's Exhibit 16A,
Well,
what?
it hasn't been admitted yet.
It has not been admitted.
After you read what has been identified as State's Exhibit 16A, what did you do?
I continued with my investigation. Like I mentioned before, I felt the scene was safe. Now I was more concerned about the victim.
Objection to the victim.
Sergeant, would you use Ms. Soul as opposed to the victim?
Yes, sir.
Thank you.
Okay. Did you notice any injuries on Miss Soul?
I did.
Could you please tell us what you saw as you observed her?
She had a small laceration on her lip, and there was a small amount of blood on her chin.
And did you come to learn that Ms. Dobro took photographs of Ms. Soul while she was there?
I was not aware of Ms. Dombrow taking photographs.
Right. I'm going to show you what have been marked. And admitted into evidence of States 4A, 4B. Look at those for me, please, sir.
Yes, ma'am.
Are those photographs a fair and accurate reflection of the way Ms. Soul looked when you were at her home around about 5:30 to 6 o'clock on the morning of January 12th, 2017?
They do, minus the amount of blood that I don't see that on these pictures here.
Okay, so are you saying that the blood has been somehow wiped up or disappeared?
Yes, ma'am.
But other than that, do those photographs fairly and accurately reflect her appearance when you were at her home at 5:30 or 6 o'clock?
That's correct.
Thank you, sir. May I publish these? Can you tell us on which side of her face, Miss Soul's face, that you saw that trickle of blood? If you can remember.
I can. It would be towards her right side in that shadowed area.
I'm going to give you a sergeant, and I want you to show us your features first.
So, very thin line from the corner of her mouth down her chin.
Was that the nightgown that you described as having pulled up?
That is.
Now I'm going to show you basically for E. And once again, that's the state of Miss Soul when you saw her arrive at your house.
Yes, there's a oxygen tube that initially she had in her nose.
And when you saw her, was the oxygen tube still in her nose?
Yes.
And can you see the trickle of blood in this photograph?
No, ma'am.
When you left the scene, what was your take on what had occurred at 3296 Brockton Lane?
I felt it was a mental health issue
And why is that, Sergeant?
for a number of reasons. The first being that she said she was in a mental health facility for the past 14 days
Yes.
and that she was there not of her own free will, which at that time did not make sense to me.
Okay, I want you to speak up nice and loudly so the jury can hear you. So,
She said she had been in a mental health facility for 14 days against her will.
yes.
And at that time, that didn't make any sense to me.
So did that give you pause about her mental condition?
Correct.
All right. Was there anything else that made you believe that it was more of a mental issue?
Earlier in that day, we're there on the 12th at 5 in the morning, but on the 11th, sometime in the early afternoon, the sheriff's office was dispatched there to check on her welfare. And from what I was advised,
Okay, that's hearsay.
okay,
Okay. Was there anything else? For example, did the email that Marianne Dogro showed you,
It's sustained.
what effect did that email have on you?
that seemed to bring clarity to the situation to me a little bit.
In what way did it bring clarity to you?
Some of the aspects of the crime scene didn't quite add up, and I thought maybe the victim was trying to get Bybee in trouble. And it also spoke to some of her mental health status.
Okay. Did you take her physical appearance into account?
I did. I did.
Inquire.
Sergeant, correct?
Correct.
All right. Good afternoon, or good morning. In taking her physical appearance into consideration, you saw no evidence that she was choked, correct?
That is correct.
And the more you spoke to Miss Soul, the more her story changed. Is that fair?
I wouldn't say that's exactly fair. I would say the story was fairly consistent, but her attitude towards Frank changed tremendously.
You gave an interview in this case back on actually January 12, 2017, to Detective Gator and Sergeant Shirtliff, correct?
Correct.
I'll show you. I don't know what evidence. I don't know where I can't. Z.
And welcome back to the Law News Network. I'm your host, Amy Dash, and I'm joined here by Marc Fernich.
Well done.
I got your name right, and your computer is not bugging out anymore.
I think we're ready to rock and roll.
How was your computer emitting noise when you had it off and closed?
I'm beaming subliminal messages to it telepathically. I'm good at that.
So listen, Sergeant Allen was on the stand.
Wow.
You're rolling your eyes. Why?
That was some really puzzling testimony that was elicited
what
on the
sense?
direct examination, because I had to do a double take. It almost sounded like he was answering questions on cross-examination. That was not remotely helpful testimony for the prosecution, and she was asking wholly improper questions about what this witness thought was the cause of the woman's injuries.
So
when he showed
why
up.
is that improper yet again? Because we've
Because
seen the
it's-
prosecution do that several times.
Well, it's completely irrelevant what he thought. He has to testify to what he saw, what he heard, and what she said.
Why do you think she keeps trying to get people to be experts on injuries who have no qualifications to do so?
Well, I think she's going to argue that they're all, at the end in the summation, she's going to argue that they're all lying and all covering up, and that their testimony should be taken to mean the opposite of exactly what they're saying, exactly the opposite. And they should take it as more evidence of guilt. And when I was sitting there listening to these wholly objectionable questions, I had to, again, do a double take, because I was wondering why the defense lawyer wasn't objecting, and then I quickly figured out that all the testimony was helpful to him, and although the questions were improper, he wants it in there.
Yeah.
Because he knew how to make a hearsay objection when there was a hearsay objection, so he obviously made a tactical or strategic decision to let this officer's mental impressions into the case, which is wholly improper but helpful to the defense. So
Yeah, and
Interesting.
another mental impression that was probably helpful to the defense is that he said right off the bat that he didn't believe her.
No, he didn't
and
believe
so
her.
obviously that shows that he was influenced by his relationship with his colleague who is the accused.
Well, that's what they're going to argue. It's really a puzzling state of affairs, very unusual, because the prosecution is going to have to be impeaching its own witnesses in summation as opposed to vouching for their credibility.
And their law enforcement, which is makes it even more unusual.
Yeah.
But I think it's interesting
tough.
because a lot of times law enforcement arrive on the scene and they have no idea who committed the crime. Now you're arriving on the scene, you have someone telling you, a victim who's alive, telling you what happened, and your first inclination is to doubt their story.
Well, not only that, his phraseology was quite telling, right? He said, in substance, I thought she was trying to get or frame Officer Bybee. I mean, there's no way he's thinking that at that moment at the scene of the crime. That's something that he devised after the fact. Very unusual procedural posture in the case, and that the defense and prosecution roles have essentially been reversed in this case. And you wonder, I mean, usually these sorts of cases are farmed out to a different district attorney's office or county attorney's office, because these prosecutors have to work with these police officers over and over and over again on different cases.
Well, was that a major misstep?
I
From the
can't-
outset,
I
why
can't
were
say.
these people even responding? Shouldn't they have immediately, like you said, called someone in from another jurisdiction
To
because they are
prosecute the
biased?
case, maybe look,
Or even to, but Mark, even, not just prosecute it, but even to
do the investigation.
process the crime scene, do the investigation.
It's the whole thing is very puzzling. You know, it would behoove the defense, if they want the venue moved or something else, to get a different prosecutor, different investigators. The fact that there weren't different investigators is great for the defense. And obviously, the defense doesn't want the trial moved, doesn't want a special prosecutor or a different county attorney prosecuting the case, because the more chaos there is in the case, the more helpful it always is to a defendant. And I think the prosecutors in this case are just going to rely on the common sense of the jury that this doesn't add up. And again, what motive does this woman have to fabricate, although in the run-up to this segment, we did a little bit more reading on the case while off camera, and she was, in fact, hospitalized previously. So the defense will have something to go on when they're arguing that her mental state is not necessarily the most reliable mental state.
Yeah, and so I actually just received some information from our producer, Kathy Rassone, who says that this judge who's presiding over the case, Judge Mason, was brought in from Charlotte County.
What about the prosecutor's office, though? Is it this is
That's a good point.
This is the regular prosecutor's office who work with these cops all the time. It's highly anomalous, although bringing in a different judge, you would expect that to happen in a case like this.
Yeah, but they're also saying that one of Bybee's defense attorneys is a former judge who's being investigated by the Florida bar.
Welcome
Can
to
that
Florida.
come in?
Welcome to Florida. Thank God. No
Welcome
offense
to
to my
Florida.
Florida friends. My parents live down there, but what's abnormal here is normal in Florida.
And that's why we see a lot of the juvenile convictions going on there. I mean, their juvenile system is another mess in Florida.
Stand your ground, all of that stuff. And I'm not opining on the merits or demerits of the stand your ground law, but nothing surprises in Florida. I mean, this is the home of the hanging and dimpled chads. So I mean, what's the irregular is the regular in Florida.
Yeah. So let's go to some testimony now that we heard earlier today from Deputy Michael Day, who also works with Frank Bybee. Like I said, the majority of the witnesses are colleagues of the accused, all from the sheriff's office. And many of them not only made comments that indicate that they tried to cover up the crime or cover up some of the evidence, but some of them also made comments saying that they just flat out didn't believe the victim. So let's listen to what Deputy Michael Day had to say.
When your partner arrived, did you speak to Miss Soul?
I did.
Okay. Did she ever tell you that she sent an email to her doctor threatening to commit suicide?
Overruled.
Would you repeat the question, please?
When you got there, did she tell you that she had sent an email to her doctor threatening to commit suicide?
She admitted to sending one, and then at one point she denied sending one.
At one point?
Yes, we went back and forth for several minutes while I was trying to evaluate her.
Deputy Day, were you interviewed by Detective Gata?
I was.
Okay, and do you have that interview with you here today?
I do.
Okay. And do you remember being interviewed by Detective Gata on January 17th of 2017?
I do.
And did you not repeatedly, at least 4, 5, or 6 times, tell Detective Gata that Miss Soul continued to deny that she sent that email to her doctor?
She did.
When you go out to evaluate someone for a Baker Act, that's a decision you would make after you interview someone and make that on your own volition, so to speak?
That's correct.
Okay, regardless of emails, regardless of anything else, you would have an independent authority as a deputy to evaluate someone and make a decision whether you think they meet the criteria of a Baker Act.
Yes.
Okay. In this case, you did that.
Yes.
And you decided that she needed to be Baker Act.
Yes.
And that was based on your observations when you were there that day.
Yes.
Okay. No matter what else happened, you made that determination.
Yes.
Okay. And you could have said no. You could have left the property.
Yes.
You didn't do that.
No.
Okay. Just for the jury's sake, there's a protocol on how that works. You would call an ambulance or something. Am I right?
Yes.
Okay. And then thereafter, you have paperwork and you take it to the facility.
Correct.
Something you've done many times in your career.
Yes.
Okay. So there's no question in your mind when you were there that day and you spoke with her, you evaluated her, that she needed to be Baker Act.
Yes.
Okay. Would you describe her behavior as delusional or paranoid?
Objection.
Legal basis?
Competence.
Experienced police officer, 20-plus years.
I've heard that he was a law enforcement officer for 24 years. I have no knowledge of his background or training during that 24-year period.
Let me ask you.
To identify mental health issues
I'll ask him that.
sustained.
Thank you. You've testified in a police officer how many years?
Approximately 24 years.
Okay. And you've gone for training after you left the police academy?
I have,
And how often do you do that?
twice a year.
Okay. And then over those 20-plus years, have you had training how to deal with people with mental health?
I have.
Okay. And you would go to calls involved with Baker Act during those 20 years?
Pardon me?
You would have calls involving people that were potentially being Baker Acted during all those years you've been in law enforcement.
Yes.
And that based on that training, you would have to evaluate someone when you went to the location to determine whether they need to be Baker Acted.
Yes.
And how many times do you think in your career you've done that?
Hundreds.
How many?
Hundreds of times.
Hundreds. Okay. And so you believe that you're in a position when you go to see someone, interview them, evaluate them, that you can make that decision?
If I have a good faith belief that that person is immediate need of health, yes,
And that's the decision you made that morning or that day.
it is.
Okay. And you stand by that.
I do.
Now, you were asked the question about whether she first, Ms. Soul, had admitted sending the email. What is your response to that? Has she done it? Had she said that to you?
At one point, she did admit to sending an email.
Okay. No question about that. She said that to you.
Yes. But then she said it was sent in the past.
And then she changed her mind and said something different.
She kept saying different things, yes.
Okay. And that happened often when you were there that day.
It did.
And who was the other deputy that was with you that morning or that day?
I believe it was Deputy Collison.
Okay. And you and that deputy were in agreement that she needed to be Baker.
And welcome back to the Law News Network. I'm your host, Amy Dash. You were just listening to testimony from Deputy Michael Day, who was talking about inconsistent statements that he heard from 79-year-old victim Marcia Soul when he responded to the scene. I'm here with Marc Fernich, who is a criminal defense attorney. Marc, you were sort of rolling your eyes a little bit at some of the testimony. What are your thoughts?
Well, what they tried to do, what the defense lawyer tried to do there in part was to get a police witness to testify about the woman's state of mind, trying to get her to him to characterize his impression of her state of mind as being delusional and other sort of psychiatric terms of art.
Based on her statements.
Yeah, well, based on his observation, and he's not qualified as a police officer no matter how many arrests he's made, no matter how many people he's recommended for mental health treatment. He's qualified to say, I thought she needed mental health treatment, but he's not qualified to say that she was delusional or whatever her state of mind is. He doesn't have an x-ray machine in his head to figure that out, and it's outside of his area of expertise.
Absolutely.
So the objection was properly sustained, and he went back and laid a much greater foundation for the officer's observations as to how she was behaving to come into evidence, and all that was entirely proper. But
I think the most compelling things in the end to the jury will be not so much the testimony of all of these people who may or may not be credible, but the pictures of the injuries, the fact that there was a car running and that there was carbon monoxide in the house. I mean, these are just obvious things that, and also in combination with him using her identity and this whole awkward relationship between this deputy sheriff and an elderly person. It just seems that really, for me, the injuries hit it home.
I think it's a very, very tough case for the defense. This is a bad case from a defense perspective. I can only surmise that no acceptable plea was offered or able to be negotiated. This is not a case that you want to take to trial, and if there's a guilty verdict, to me, this is, I mean, we hear a lot of protests against police officers, Black Lives Matter, et cetera, and there's good and bad in every bunch, be it the Black Lives Matter protesters, and same is true of police officers. But this is very ugly police behavior if he's proven guilty and the cover-up for it. And it shines a light on this type of elder abuse. I mean, this is truly a vulnerable population. And if it's true, it's despicable, and you'd like to hear about this getting every bit as much publicity as the Black Lives Matter stuff, because this is just as, if proven true, just as horrifying. It's very bad.
Absolutely. And so I want to just switch gears, though, for a moment, because I was talking earlier with John Rothstein, who's a college basketball insider from CBS Sports.
God help him.
About, he's running in a million directions. Exactly, because this news broke, which is unbelievable, and it's rocking the college basketball world to its core, because what it is it's a federal investigation into how recruitment happens in these high schools and colleges. And the people that really prey upon these athletes to try to get the standouts as their clients before they even make it to the NBA. And they do this, according to the federal documents, by trying to bribe coaches. And we saw that a couple of coaches, according to the government, accepted these bribes and used their influence to try to steer athletes towards financial advisors and agents in the event that they make it to the NBA.
Well, of course, none of this is anything new, Amy. Back even before I became a lawyer, there was the very famous agent in Chicago, Norby Walters, who was a very early racketeering prosecution for improprieties in recruiting and paying bribes to get college athletes as his client. And he was convicted of racketeering, and the case went on for many, many years through the federal courts in Chicago up through the Seventh Circuit, and Walters' reputation was ruined. So the government has been prosecuting these sort of things as racketeering for quite some time, and of course anybody who works in my little of the world remembers the Boston College point shaving scandal. Back in the 80s, it was part of the movie Goodfellas. The mob was doing that, and so this is just more of the same. We've had a lull in these sort of prosecutions federally for quite some time now, and in my view, and I was listening to your guest on the video before I came on, this really points to a more systemic problem in the world of college athletics. And in my alma mater, Northwestern, my law school alma mater, they tried to fix it by unionizing. And that bid was ultimately shot down. But these are, for all intents and purposes, these kids, these are, in basketball and football at least, there's no pretense that they're anything but farm teams for major sports leagues, and we should treat them as such. They're student athletes.
But so let me ask you this, though, then, Mark.
These
people who have been arrested and charged, the players that are involved, the coaches that are involved, the financial advisors that are involved, there are about 10 people charged right now, but we're expecting more chips to fall. Did they just get a case of bad luck? Because couldn't you essentially go through and find more coaches, more players who for decades have been doing the exact same thing, and these people are just being made an example of?
Well, but that
you could shut down probably the entire NCAA, every single team at the college level in basketball and football, potentially.
But that happens in every prosecution. You could shut down the entire Wall Street for being corrupt. You could shut down the entire New York legislature for being corrupt. You could shut down the entire Washington for being corrupt. You could shut down half the United States for not paying their taxes properly.
But so then where does it start and end? Because you have players now who are probably going to be ineligible. Meanwhile, there are people who have made it to the NBA, major players, who probably did the exact same thing when they were in college.
It's not the players who are alleged to be victims here, and this is one of the
well, they are in a sense.
Well,
you know why? Because they place their trust in the coaches. And there is a recorded testimony to that effect by the FBI in the sting operation, where the parents are saying, we trust you, coach, 100%. Thank you for surrounding us with these people who you say are going to help our son manage his affairs. A lot of these people are impoverished. They don't have any idea how to manage millions of dollars.
Right, but we have to separate out the sympathetic aspect of it from who is being named as the victims legally here. That's a bit of a problem for the government. So there's two schemes alleged, right? The first scheme is to steer players to certain agents.
Right, and financial advisors, even a suit maker.
Right, and vendors, we'll call them vendors.
Vendors, sure.
And in the second scheme, they're being steered to certain universities who are backed by Adidas.
Right, sponsors, which I'm sure similar things were going on with other major sponsors, but Adidas was caught in this sting.
So the first victim,
well, a rep, I should say,
the first victims in scheme one are the employers of these crooked coaches. They're being deprived of these coaches' honest services. There's really not an allegation that any financial loss was suffered, and in fact, it's completely a fiction, right? Because these universities, Louisville and Miami, are, if anything, actually benefiting from getting the services of these star players. They're being exposed, of course, to NCAA sanctions if this is being done without their knowledge.
And that's where the honest services comes in, because if they're doing this without the university knowing, the university can incur the NCAA penalties, and the whole program could be shut down. So they're being deprived of the honesty of their employees.
They're breaching their duty of loyalty, a fiduciary duty of loyalty to the employer, which in this case is the university. So that side of the scheme seems to be on pretty solid legal footing as to who they're alleging to be the victim. Okay?
Right.
Put that one to the side. The second one.
But wait, let me ask you about that. Then, if the universities are alleged to be the victim,
Yes.
under, you said, this honest services fraud charge,
Which, by the way, is perhaps the number one bane of the Supreme Court's existence in the world of criminal law. In 1987, in a case called McNally, and as recently as 2010 in a case called Skilling. I mean, this statute is such a mess, the law is such a mess, it's so vague, it's so open-ended, that the Supreme Court has continually, over the past several decades, had to take steps to narrow its reach, because you can use it for practically anything.
But my question is, then shouldn't the NCAA, Mark, not shut down these programs, not fine the universities for their employees' violation of the rules if they didn't have knowledge that this was going on?
That's gonna come out. How high up it goes.
Like, why should the whole school suffer?
Well, because a corporation or an entity such as a university can only act. I mean, it's a legal fiction that it has a separate existence. It's comprised of its employees and high-ranking agents. So it depends how high up knowledge goes. If it's a rogue assistant coach, then no, the program shouldn't get the death penalty. If it goes up to say a Patino or somebody in a senior management capacity, or a president of the university, a high-level person, like it was alleged with Sandusky that Paterno had knowledge, then of course the program is going to be sanctioned. But let's put that one scheme
Okay,
to the
so let's
side
go on
for
to
the
scheme
moment.
number
Scheme
two.
one, it sounds like a pretty good case, and this is again just based
You're
on
saying the
whatever it's
victim is clear here, it's the university.
Pretty good case for the government.
Right.
The second scheme, I don't see a fraud victim at all. In that scheme, I don't see a fraud victim at all in that scheme, because the university is getting the benefit of these star players who are coming there for illicit means, supposedly because the university is backed by Adidas. So the university didn't lose anything there. It didn't lose honest services. No assistant coach was corrupted. It went from the company, Adidas, through intermediaries directly to the players.
But some of the
families.
coaches made calls allegedly to the company, the Adidas company, to get money for the players. One of the coaches was involved in a meeting that was taped by the FBI, talking with one of the reps from Adidas about giving money. So in that sense, isn't it the same thing with honest services fraud?
If that turns out to be true, and they're hanging in on an honest services theory, that will stick, and the agents, the Adidas folks in there will be potentially liable for conspiring to deprive the university of the intermediaries' honest services. But if it's not being funneled through anybody with the university, it's hard to see any kind of victim there at all. And again, it's in my view a sorry state of affairs that the federal government has to use my tax money and your tax money and everybody else's tax money to police the inner workings of the NCAA, which is essentially a professional farm team for the NBA and the NFL. And our tax money is being used for this. I understand why it's being done, but if we would just remove the legal fiction that this is a real student-athlete program and just call it what it is, we could use my tax money and your tax money to go after terrorists and the other things that really jeopardize the interests of this country.
But to your point, and I guess maybe what plays into this is some of the athletes might fear that they incur injuries and wouldn't make it to the NBA if they finish out their college careers. But to your point,
I don't know.
The
Listen,
legal
people
documents
go into
and
this with their eyes open. I mean,
no, but listen, Mark, the legal documents, the FBI, there are coaches who are saying this one's a one and done, meaning he's going to play 1 year in college and then we're going to advise him. Even in the documents, one of the coaches says, I told him he's got to go to the NBA after a year of college. They are encouraging these students to not finish out their college careers.
Just
like you said,
just underscores my point. This is a fiction. It's a joke. And all the universities are not, I'm not saying they're complicit and they're in on exactly what goes on here, but these programs like at Duke, which is of course an outstanding university, but places like Louisville and Miami, these programs are cash cows for the university, and it's just a complete charade that these people are anything but mercenaries and hired guns for the university. Let them unionize, like I think his name was Kane Coulter, the guy at Northwestern, proposed. Let them be treated like quasi-professionals, and let's dispense with the fiction that they're student athletes. Come on. I mean, at some schools, yeah, where, at Duke and at Northwestern or at Stanford, that they have to have the chops to stick with the program generally, although I went to an Ivy League university and I saw what was done in the 80s with the athletes. They didn't belong in the classes that I was in, and that was okay. We all knew what was going on. But let's just call this what it is and treat them like a farm team as we do in the NHL, my sport of choice. I mean, college hockey is increasingly on the upswing, but we've always had farm teams for Major League Baseball and another college sport on the upswing. But in baseball and hockey, you have a farm system generally where the bulk of the players used to come from, although they're increasingly coming from college now.
So let me ask you this.
Let's call it for what it is. Let's just have some honesty and some transparency in it, and we don't have to have these sort of example-setting prosecutions like you picked out, one out of,
Yeah, and they use these hokey terms in the pressers, like, we've got your playbook,
well, that was,
let this serve as a warning. I mean, does that sort of undermine the seriousness?
It does.
But the FBI always does it. The government always does that.
Didn't like it one bit, didn't like that
love
press release
taking
one
the
bit.
lingo.
Hoop dreams.
Hoop dreams.
I didn't like it one bit.
They love taking the lingo and making fun of the fact that people's lives are now ruined. And I'm not saying that they're not culpable and didn't do it to themselves. But why make this into such a jokey type rollout? Like, look at us, we got them.
That's the
you don't gloat if you're the government.
No, you do, because that's the society we live in now. We live in a tabloid society, and I must say, I don't usually read their press releases because I'm ready to bang heads with them. But I went to court this morning, so I had to get ready to come here, and I read the press release, and I wanted to throw up from the press release because of that.
But is that inflammatory, though, Mark?
It's a joke.
But is it
Absolutely.
also inflammatory on the case?
It taints a jury pool. I have no time and no patience for it. And in a friend of court organization, a defense organization that I'm involved with, I co-signed a friend of court brief in the Shelley Silver case because they tried to taint the jury pool. And look, lo and behold, not for this reason, for another reason, because of the McDonald case, Shelley Silver's conviction was reversed by the appeals court here. Shouldn't be doing this. They don't like it when defense lawyers do it. I don't like cheap, showy tricks by defense lawyers. And you're right, the government, their job is to do justice, not obtain convictions, not taint jury pools, and not use ticky-tacky rhetoric like that. My job as a defense lawyer, by the way, for the viewers out there, is very different from the government's. My job...
but you can't say that defense lawyers should be able to do it and not the government.
Yes, we can.
Why?
Because my job, I have different ethical duties than a prosecutor. My job is to represent my client and get that client off by any legal means necessary.
But you can taint the conviction as well.
I'm not allowed to do that because there are court rules locally that prevent me from speaking about the merits of the case in public. It's very clear, and these court rules are written to comply with the First Amendment, and they've been upheld for better or worse by the Supreme Court and by our appeals court. I'm limited in what I can comment on about a pending case. This is a scam. I mean, look, Preet Bharara, the late, great Preet Bharara, went down and beat his chest at a speech downtown. I don't remember if it was at New York Law School about draining the swamp in Albany while he had pending cases on, while he had just indicted Shelley Silver and while he had just indicted Peter Skelos the day before or a couple of days before. He's commenting on pending cases. He's tainting a jury pool. If you want to do that, Preet Bharara, run for office, which you're going to be doing in 4 years.
Well, no, now he's a talking head on CNN.
Well, now he can say whatever he wants. He's just getting ready to run for office is what he's doing.
So listen, I want to ask you lastly with this NCAA case, it was set up, the whole thing was set up by an advisor, a financial advisor who was brought up on charges by the government for extorting money in a Ponzi scheme for professional athletes. They made him a mole in the case. He went undercover and he met with all these other financial advisors. But what he did is he said to people, find me coaches that want to accept money to give their students to me as their financial advisor. This is the mole. Is this a sting that can be effectively challenged with an entrapment defense, meaning you set me up and I would have never taken that money from you if you hadn't been working for the government and asked me to do it.
Very tough entrapment. Look, I've been in a number of entrapment cases. It's a very tough defense to make because you have to show lack of predisposition, or more precisely, the government has to show that the person was predisposed to committing the crime to rebut the entrapment defense. And if the defendant jumps at the opportunity to commit the crime without much coercion on the government's part, the judge or the court will rule that that's evidence of predisposition, and although there was government influence to commit the crime, the defendant was predisposed to do it, and all he had to take was a little bit of a nudge, and that will rebut an entrapment defense. So you put it before the jury for color. Maybe they'll buy into it because of just how sleazy, although permissible, the investigatory tactics were, but the chance of prevailing on an actual entrapment defense when these practices are so prevalent in the industry are slim.
I want to talk really quickly about a trial that we're going to be covering at 1:30, the Morris brothers. These were people who were two NBA players. Okay, and
these are wonderful role models, the ones who are taking the knee and doing social justice for all of us.
Well, I'm not even going to get into that, Mark. I'm not even going to get into that, Mark. But listen, because
wonderful role
that's
models.
a whole
Watch the NHL.
That's a whole nother topic for another day, because then you're bringing Trump into it and politics, and
we wouldn't want to do
everyone's
that.
going to get really heated. But listen, these NBA players, they're brothers, and they are being charged with aggravated assault on somebody. Okay, but the problem is that during the trial so far, there have been numerous witnesses, including the victim, who took the stand and admitted that he tried to extort money from these people in a settlement. He was expecting $7 million when he said that the charges were brought up, to drop the charges. Several of his friends said that they were asked to lie. One of his friends made a joke, "Oh, we're going to get rich off of this because I witnessed it." And she took the stand and said that.
Got it.
Oh, but she says I was joking. So is that enough to get these brothers off? The fact that even the victim admitted that money was a motive here. Not necessarily, it doesn't necessarily mean that he wasn't attacked by these brothers, but is it enough to get them off?
No, you just nailed it, actually. You can't resort to self-help. You're supposed to go to the police. That said, so it's not a legal defense, but no jury is going to be sympathetic to people who are trying to extort the athlete. And you're not allowed to use the "he deserved it" defense to get out from under a beating. But we as defense lawyers do that all the time, and often it will work viscerally with jurors, and they won't want to return a guilty verdict in a case like that, although it's not a true legal defense at all. I mean, if somebody steals my money or sets me up, I'm supposed to go to the authorities and not punch the first person in the face, although there are people who will think on the jury, man, this person really deserved what happened to them, so I'm not finding the guy guilty. I would have done the same thing if I were in his shoes.
Well, it looks like we might be going back to the courtroom soon, so let's revisit Bybee for a minute.
Okay, sure.
Again, Frank Bybee, just to remind our viewers, is a deputy sheriff in Sarasota, Florida, who is accused of attempted murder of an elderly woman named Marcia Saul. And the allegation is that they developed a relationship over time, that he tried to steal her identity in a number of ways, that he burglarized her home and attempted to kill her when their relationship soured, and that he did so by trying to force medication down her throat. And when that didn't work, tried to poison her with carbon monoxide by turning her car on.
He was a very resourceful guy, Frank Bybee, sounds like.
Allegedly.
Allegedly.
Yeah. And so I'm here with Marc Fernich, who is a criminal defense attorney here in New York.
I wouldn't want to be defending Frank Bybee, I can tell you that right now.
You wouldn't?
No, it's not.
Because
not a case that I would find very savory.
I
would ask for a lot of money from Frank Bybee.
But you have clients pending right now who are far more devious in the public perception than Frank Bybee, do you not?
They're not cops, though. I mean, you don't like.
So why does that make such a difference for a defense attorney?
It doesn't. Look, I can't speak for the entire defense bar.
We've seen a lot of cops acquitted in these unarmed civilian cases where people have been killed. It seems like it would be easier to defend a police officer.
Well, if this is true, it's premeditated. I mean, these unarmed shooting cases arise in the heat of the moment, spontaneous police civilian encounter, unpredictable, can spiral out of control very quickly. I think we discussed this the last time I was on here, subject to misconceptions on both sides, and the situation can get explosive pretty quickly. If this is true, this is a long-term premeditated pattern of elder abuse designed to bilk somebody out of their money, apparently, and if it's proved, it's pretty reprehensible behavior. So that's not, you know, people are entitled to a defense and a defense lawyer. That doesn't mean they're entitled to this defense lawyer, me. So, you know, if I have scruples about a case, it's not a case that I'm personally going to want to take.
So you're saying that defense lawyers do have scruples about
again,
cases.
I can't speak to.
Because I think
I would
the
sell my
perception is the
scruples if
opposite.
they paid me enough money
That's
to
what
sell
I'm
my
saying. There you
scruples.
go.
I would.
That's the
I would.
truth.
I would say that, but that said, I would charge Frank Bybee a fee that I probably think he can't come up with because I don't like the case.
Meaning that you need a certain amount of money
Yeah, I'd price
to
myself
compromise your scruples.
Correct. I'm not.
Meaning you have no scruples.
Well, I have loose scruples. Let's put it that way. I'm not going to say I'm better than anybody else. I mean, but no. To get serious for a moment, I've been approached to be in high-profile terror cases. High-profile terror cases. It's against my ideology, obviously. I don't really want the case, but if they pay me enough money, that's my job, and I'll set a very, very high fee in the case, knowing full well that they probably won't be able to meet that fee, and that'll resolve my ethical dilemma for me.
So that you can sleep at night.
Oh, I sleep at night no matter what I do, because that's the job. I mean, I didn't invent the system. I'm just part of it, and I'm not here to change it. I think on the whole, it's a system that works better than in a system that anybody else has managed to come up with.
Yeah, and so I think we're hearing some